Start. Yeah. On that case. Hopefully, should have so yeah. So unfortunately, so joining online cannot enjoy the cake and all, right? Right. Anyway. So did you guys get a chance to look at the tables? That honest answer. Anyone? I'm seeing some new okay. In the last section. I'm not sure. Okay. Anyway, all right. So, did you get a chance to pick this up? No, is it work? You all are working, right? On weekday. That's pretty difficult, no? I mean, yeah, it was 7 days, no break. You guys decided to do this. You guys decided to do this, like you know, going to take me and supposed to work and stuff. No, like you guys decided to do this way so you can make a living or like learn and also study. Education. But different, right? When you are a full-time student, you have more time, you can do research, study on your own. Yeah. So I'm assuming none of you want to get into teaching, like lecture. Yes. Yeah. A lot of reading to do. Okay. So we did learn about promoters in the last class. You recall? Yeah. Yeah, we did learn about promoters. So before we move to pre-incorporation contracts, can one of you tell me who a promoter is?
Yeah.
And who takes necessary stuff? Still, it becomes a contract, right? Not just a person with an idea, but actually someone who takes it to the next step till it becomes a complaint. That's a promoter. Right. So we looked into their responsibilities and all duties and remedies. So let's actually look at the questions. A quick recap of what we learned. Then we can go to the next one. Yeah. So anyone who could tell me the duties of the duties? Is it like of course that's like your book? I'm asking like duties when they do that. So I think that's something very important that yeah, you have to understand what's the aim behind the question. Okay, not sometimes, most of the time, what happens with low subject is people just think it's about just writing, chunks and chunks of it, like paragraphs, like lots of stuff. But that's not the case. There is always like very, what to say, it's not like math, not like 1, 2, 3, like it's not that specific, but there is specific expectation that's placed on you when the question is posed to you. I remember discussing this, right? Duties as how you should answer. Comfortable? I remember doing. Anyway, so can any other one that we like to try the duties of a promoter? No clue. Yeah. 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 Sorry? Yeah. See? You just write like a case name for an exam, no one's going to give you marks because that's not telling us what you learned from that, right? So I'm asking, you said promoter is someone who takes initiative, who comes up with an idea and takes necessary steps till it becomes a company, right? So that's clear. And then we looked into the very specific boundary that's set by the law. I say it's a party to the prospectus. Right? Do you remember what a prospectus is? Yeah, like a very initial document that they publish, even like universities have prospectus, right? So if you have, I don't know, I think it's very common in Srilanka, but in other countries, once you finish high school, you have, like you can apply to like hundreds of colleges, right? But the thing is, nowadays you would check their website, what kinds of programs they have, whether they have a financial aid, whether they have a scholarship scheme, right? But you will check in a website. But earlier, and nowadays also they publish, but they have prospectus. That basically gives you an idea. Have you guys seen? I think even here they have a prospectus with like course name, details, like what are the subjects taught, and stuff like that, for how many years and all, like the basic information about it. So before that initiative, whatever becomes a company, before they have an article of association, a constitution, right? We come up with this prospectus. So then later they specify it saying a person who is party to that prospectus is a promoter. And there itself it specified one duty. What is that? Yeah. Yeah. Disclose information is one. Yeah, that's good. But there, the very first one is that he should not give any untrue statements in the prospectus. That means you have to have full transparency with the investors. The very first one is that the duty to be true and fair, that have the true statement. So that will be one first one. And what you can cite for it, you can just keep the section 41 subsection 6. But 41 subsection 6, you remember this? Yeah. So it comes with saying that the person, if it contains untrue statements, then it cannot be a person acting with their professional capacity. And what's the next one? The duty to do what? Duty to disclose information, right? To disclose information regarding a full disclosure of all the information relevant to that particular company, right? So here again, what you can do is you can just say full disclosure of any information, and you can just say they cannot make secret profit. Okay, and you will cite this case. In the case of this one is for profit. You will cite this case and say they cannot make secret profit. Another one is they have to disclose a duty. They have a duty to disclose any conflicts that they might have. Do you know what conflict is? Not like white conflict, it's conflict of interest that they have. Do you remember this case? A very smart person bought an island on his own name and then later sold it to his company. Anyone recalling anything? Looks like nothing went into your head since the last class. Right, so basically what happened in this case is a person, he bought an island with his own money and later sold it to his own company. But then he didn't tell that to the investors. Right? So that's actually pretentious. Like he was taking more profit to himself, but he didn't reveal the details to the investors. Later he was sued and he had to pay back. Okay? So if you couldn't even remember this whole, new somewhere or perspective, just remember a person bought an island on his name, later sold it to the company or doubled the price, hiding the fact that he was the owner. When the investors learned that he did this, they sued him. Right? And the court held that the promoter has the duty to disclose any conflicts they might have. So maximum 3 or 4 sentences. That's all. So you will write the duty You will cite the case name. If you cannot remember, you will just say in a decided case, you will just write the case facts in 2 sentences and we'll say the ruling. Okay, that's how you should answer. Structure. Don't just go write and all everything you know about promoters. They ask about duties. If you know 2 duties, specify those 2 duties because that's how you are marked. For writing a duty, for adding a case, just explaining it. Okay, not like for pages and pages. Okay. Any questions? Yeah. Anyone? Any questions? Right. Then the last one, the remedies. First thing is, what is remedy? Solution. So for medicine, so if you get sick, medicine is like a remedy, right? Similarly, when you have faced an issue with a contract, you have remedies. In this situation, what can happen? Parties can either cancel it, or they can accept it, or they can ask for damages, recover their profit, or they can claim damages for the breach. Okay? Now let's move to pre-incorporation tracks. Right? You have this presentation, right? And then this is not good. So pre-incorporation, you will have all the presentations by next week. Huh? Oh, so that. So pre-incorporation contracts. So it is actually what it is said in the name. Okay, pre-incorporation contracts. Any contracts entered into before the company is incorporated. Pre means before, right? So pre-incorporation contract means any contract entered into before the company is incorporated. Right? So here we are going to focus on 2 different things. Right? So if you could recall what we learned in director's duties, you must have understood that I told you how over the years the case laws have set a higher expectation on a director's duty. Right? Initially, they said like they don't owe any duties to shareholders, they only owe it to the company. They said they are answerable to the shareholders. Later, they said they have to exercise a higher standard of care when exercising their duties as a director. So that's an example of how law developed, evolved over the years. But here what we are going to look at is the law evolved and then later we have actually changed it. Right? So first we will focus on how the law developed through cases and then we will focus on how it changed. Right? Okay. So first one is common law. So common law basically means the case law, right? In this context. In another context, it has a completely different meaning, but since you haven't studied legal systems and all, I don't think you will get confused. The previous class asked me a question. So you just think common law means the case law, how law developed. Okay, before the statute came, the Companies Act. So here, the first one is Kellner versus Baxter. As you can see, it's a very old case, 800s, right? 1866. So the promoters of company, they entered into a contract on behalf of it, of course, and they purchased wine. Okay, so they purchased wine, but they didn't make any payments at that point, right? Later, for some reasons, they did liquidation. They couldn't survive as a company. So now the question is, who is accountable for what? Who takes care? Because they have purchased the wine. Now it's sitting there. Who makes the payment? Whether the wine should be sold back, the gain, whether it should be sold, like so many uncertainties are there, right? Because we don't know what's going to happen. So then the promoter, they actually sued based on the contract saying that we need the money back. Okay. So then the court held that They thought like since now the company has become incorporated, now it is responsible for all the transactions, right? Earlier, promoters, they had an idea for a wine business, right? They went and purchased wine on the name of the company, but it was the promoters who did that. The company is not there yet. It's not incorporated. They had this idea and like in a way to take it over, they went ahead and bought these wines, purchased these wines. Okay. But now what they are trying to do is saying that now since the company is incorporated, they can ratify it. Are you familiar with the term ratify? Yeah. Okay. So in law of contract, that's like the founding, right? That's why since you skipped that, it's whether you get that understanding. So usually an agreement contract, all of that is created through express instructions. So if I want to enter into a contract with a person called A, right? What I have to do is I can enter into an agreement in writing. I can sign an agreement, have terms and conditions, and I can sign the agreement. Another one is orally, I can say so and so, and that can also be binding, right? So in Sri Lanka, oral contracts are also binding, right? So not necessarily all the things need to be in writing. So keep that in mind, right? So either it should be in writing or it can be an oral contract, right? There can be another way where we assume that there is an agreement when we call it implied. Through their conduct, we just assume that there is an agreement. A good example would be, let's say there is a shop and it has one owner and 3 salespeople working there. Okay. And during the lunch hour, the owner goes to his home to have his lunch. So during that 1 hour, one of the senior salesperson there takes his position as a cashier and he takes care of the matters. Whoever comes in, vendors, lender, product, who comes, he takes care of the matters. Okay? Though this whole scenario is not just happening today, but for a couple of years, it has been the practice in that shop. Okay? So now we can say there is an implied agreement between this owner and the salesperson regarding who takes care of the shop for that 1 hour. I don't think they will have a writing saying, when I go for lunch for 1 hour, you have to take care of the shop. That's not a practice, right? Usually they will not say. Maybe they could have said it out loud saying this, or what they will do is, have a look and they will just go. So then we can say it is implied through their conduct, through the way they function, operate, we can assume that there is an implied agreement between those two, right? But for example, he must have given very clear instructions that you can take care of our regular transaction, but if a new vendor comes in, if a new distributor wants to introduce, let's say, a different kind of biscuit packet, you can't make decisions on my behalf, right? For like such decisions, the owner has to be back unless he has authorized that one also, right? So this is how usually the agreements are formed and contracts work. But there is another kind where we call that contracts are created in a way where it can be ratified later. So in the example, let's say during that one day, like in one lunch hour, the eldest son of this shop owner comes to the shop. And now he is sitting in the cashier desk. A new vendor came in and he looked at the product. He was happy with the product and the price and all. Maybe the discount that they are offering. So then he decided to accept their offer. Okay. So now he has agreed to that and his dad's coming back. And coming back and he's saying, okay, his elder son is done that. So this is not a practice. So we can't say it's implied, but it is not expressed because the father didn't say anything about it, either in writing or oral. But what we can do now is, the first thing is, at the face of it, you can say, the son can't do it, like he doesn't have any authority. to do that on his behalf. But what they can do is, he can come back subsequent to the act. After the act, he can ratify it and make it valid. Saying that, okay, he has done this, looks like a fair decision, so I'm ratifying his act. That means that he makes it valid, legal. Okay, so this is how ratification works. After the act is done, you ratify it. So similarly, here, the expectation is you sign something, you as a promoter sign it, but later, once it becomes a company, the company will ratify it, saying that they did it on my behalf. So now who is accountable? The company. Right? So that's the presumption. But when this idea was taken to the court held that since at the time of entering into the contract, the company was not alive, it was not in existence, that the liability goes to the promoters. They have to individually take responsibility for that. Why? Because at the time of entering into the contract, the company was not there. So you can remember it this way. Can a dead person enter into a contract? No. Can a born child enter into a contract? So basically, before a company, it is an unborn child, right? So once it becomes an adult person, a child, it's born, grow up, it can ratify an act. Let me go back. But the contract will not be valid. So this is the old position. That's what in 800s they assume it as that. Is that clear? The basic idea is at the time of entering into the contract, the company was not in existence. So then they said liability goes to the promoters individually. Okay. So similarly, if you look into the other cases, more or less it's the same. I'm not going to take too much time. Same situation. It was a business related to ham. You know ham, kind of meat, like beef, pork, and all ham. It's a different kind of meat. So basically, it's about that business, and then again they entered into a contract. Court held company was not in existence. Company was not alive, right? It was not there. So the responsibility is for the promoters. And later, in the case of English Colonial Produce Company Limited, they argued, okay, this is how the precedent is. This is how you have ruled in all the cases. But now the company has gotten some benefits from it. It has taken benefits out of it. Let's imagine they have signed a contract and they have made purchases, they have sold the things, and now it's making profit, and the company is having this profit. But an issue comes out. Then the court said, even if that's the situation, still the company is not responsible. It's the promoters individually. Okay? So the individual promoters are responsible for that. More or less it's similar, so you can just read it through. Okay? So that's the position of common law. Right? So you all know that company is a legal person and promoters are legal person. But as of the common law tradition, what it's saying is they are responsible for any contracts entered prior to incorporation. Right? So that is common law. So it won't bind the company. But now what happens is, so everyone was, as you all know, law is a living document. It just keeps changing and evolving, right? It's not like fixed. It always keeps evolving. Okay. So what happened was they started discussing if we are going to be this strict on the promoters, it's going to affect promoters from taking the risk of starting a business. Because think about it, if we are going to put this pressure, saying that if things go wrong, you are responsible, the individuals will have a worry as to take the new step. What if things go wrong? Or I'm going to be liable for everything that's going to happen. then what they decided is, as you can see before the act, no. But in the Companies Act, in order to facilitate shareholders that they will have something to trust, and also to facilitate the promoters to keep them with some confidence that they can take this forward, we have introduced some conditions to pre-incorporated contract. Yeah. Now we can make it valid by ratification. To be very clear, common law said no, not binding on the company because company was not in existence. Why it kept it that way for a long time? Because that entire idea was placed on the premise of law of contract. Because contract law says a person who is not alive or not in existence cannot enter into a contract. Right? Makes sense now? So, even if, like for example, like the dead person, if he will come back alive, right? Let's say he was in a coma or whatever, I don't think it will happen. If that's an example, he cannot come back and ratify it because at the time of signing, let's not even take a dead person. Let's say the person who is in a coma, right? Do you think he can enter into a contract because he is not in the right mind? So, but the law will look into whether that person was in the right mind at the time of contract. Later, he could have come out of the coma and now he is functioning all well. But whether he was capable of doing that at that point, that's the question. Okay. So, if the answer is no, then you cannot make it bind on the company. So, to secure the investors and to facilitate shareholders, in the Companies Act, they have included statutory provisions to protect the interest of both the promoters and as well as the investors. Okay, so this is how the definition goes. Section 23. The contract purpose should have been entered into by a contract before its incorporation. So basically, just an explanation. Contract entered before company is incorporated. So you don't have to like memorize it, just remember it. Or contract entered into by a person on behalf of the company before its incorporation, either itself or on behalf, representation. So that's very straightforward, okay? All right. So as I told you, this provision was introduced into law to give protection, right? So how can we give protection? That's the question. How can we build this trust with the investors and the promoters that later on that the company will take responsibility for this, right? So that's how the whole concept of implied warranties were introduced. So let's look at a real life. Do you all know what warranty is? Yeah. When you purchase a mobile phone or when you purchase a laptop, they give you warranty, right? Why do they give you warranty? What's the purpose? Okay. Assurance, yes. Assurance, like the quality of products, whatever. So if something goes wrong with it, you can come and fix it. What else? Why would they give you warranty? Even for electric bulb, we will go and ask about the warranty card, right? Even for such a small thing, we go for warranty. Why? What's the importance? I'm sure you must have studied that. It's from your experience, from your knowledge, just tell me why. So if you are running a business and if you have products, do you think it should have warranty? Yes, why? Or is it curiosity to be right, trust. The one of you mentioned assurance, right? Trust. So the idea behind even purchasing an electric bulb is that the customer is not left alone when something goes wrong with it. That basically what we are saying is, we will take care of your product for this particular period of time. That we will continue this relationship, like basically saying maintenance, right? For that 1 year, we will check. If you come back to us with a problem, we will try to solve it for you. So it builds a trust on the product and gives you assurance. Similarly, same concept. Now we want to give this trust. We have to gain the trust and build this assurance with investors. That they have to trust us because they know that the company is not in existence now. Right? So if they trust the promoters and if they just run away, that's risky. So they will be like, these are randomly, let's imagine that 3 individuals, like you, came up with a really amazing idea. Now we are going and meeting like rich billionaires people who are potentially could be your investor. Do they know you? No. You are just people with bright ideas, innovative thinking, and you have the energy to work and everything. But you don't own a property, right? You don't have anything except for that idea and that energy, right? That will to like run this business to come up with your own thing. You don't really have anything. So how can they trust you? That's the question. Similarly, on the other hand, you are young kids, not kids, but like young people, right? So it fear will come to your mind if things go wrong, and we are all individually liable for whatever goes wrong with the business. Then I have to pay from my own pocket to settle things, right? So in order to gain that assurance and to get that trust, they have included implied warranty. So implied means it is already there. That's something you have to assume. You don't have to individually go and write it in every contract you sign. It's implied because it is a statutory law, right? It's already there. It applies to every single pre-incorporation contracts. Okay? Because it's a law. And what does this implied warranty say? It sets out 2 warranties, right? And two assurances to the investors. One thing is that the company will be incorporated within a specified period mentioned in the contract, saying that this company will be incorporated, because when you are signing it, it's not there. Okay? Be very clear, when you are signing this, it's not there. Let's actually take an example. So you want to start a factory, right? And now you have purchased a land, right? You have purchased a land and you have purchased, and now it's the process. You have to sign a deed, right? You have to sign a contract. So now if you want to sign this, there is no assurance because you are going to buy it from your own money because you don't have that money. So who should give you the money? Investors, right? So investors are going to give you the money. But the problem is, what if you, let's say 3 people run away with that money? It's a problem. Right? So one thing is, that person can take you to the courts under contract of law. Take you to the courts and sign this contract with them, trusting them. But the problem there is that investor wouldn't have signed a contract with those 3 members. He would have paid for the property. Then the problem is with that person who sold it to him. So then he will be nagging him for the money, and it's a completely complicated situation. So no one wants to deal with that mess. So what we are going to do is, we are going to have these 2 protections, 2 layers of protection. One thing is saying that when you enter into such contract, for example, land, there is an implied warranty that you will incorporate the company within a specific period stated in your contract. Let's say 6 months. You can specify it for 6 months, and by the end of 6 months, you should have your company incorporated. But in some occasions, they will just add a clause saying within a reasonable period of time. Right? So that is to be on the safe side. So imagine a situation where you did this transaction that I just mentioned in 2020, early 2020, and you promised that you will incorporate it in 6 months. But what happened in 2020? You were all like alive, living and present in this world, right? During 2020, not even like a Sri Lankan thing. What happened during 2021? What happened? COVID happened. My goodness. Right. So COVID happened, and because of that, it could have prevented them from actually incorporating the company, because that disrupted a lot of business. Right. Then the issue is whether that is a smart way of actually specifying the contract period. If they have included a term saying within a reasonable period of time, then even if it's taken to the courts, they will say, it was not reasonable to say that this is a breach because it was practically impossible to carry on business during that period, right? So you can either say that the company will be incorporated within the specific period stated in the contract, or you can say within reasonable period of time. And you all understand why we use that broad phrase as reasonable period, because reasonable period differs based on the context, right? So no one expected COVID. So something like that could happen. Okay. So recently you must have seen the non-academic staff went on a strike for 75 days, right? No one expected. So imagine if universities sign contract with, I don't know, private companies to conduct a conference or maybe to have a fund collection event. Everything went into issues, right? Because it was closed. No one could even enter into the university because they went on the full-on strike, right? So those impractical things would happen. But the things that will happen that will make you to practically perform the assigned task. The next condition, so it's an and, that means two conditions, both should be achieved. The next one is that the company will ratify the act, again within the period specified in the contract or within reasonable period of time. So this means that now if you sign a contract, if you sign to, or if you go and buy a land, there is an implied contract that you will incorporate your company within a reasonable period of time. And once it becomes incorporated, you will ratify the act. So then the accountability and liability will transfer from the promoters to the what? To whom? Will transfer from promoters to the company. So then the promoters will go out of the picture. If the promoters want to stay in that company, they can stay as shareholders, maybe like questions, whatever. But even if they want, like, okay, we came up with this idea, it's all fine, but we don't have the time to invest in this, they can just hand it over to the company and they will take it from there. So then the responsibility is with the company. That's why we have now included the implied warranty. Right? Is it clear why it is implied? Because it's not something you write in the contract expressly that we will incorporate within this period. We will incorporate within this period of time, and after that we will ratify it. It is implied statutory law, so you cannot breach it. If you breach it, then you have to face court case, right? Because it's a law. Right. So this is about what happens if you breach it. So of course, law is first thing it will say positively what you have to do, and then it will say if you don't do, these are the consequences. So every single law will have that. Okay, right. So then the amount, this is just a calculation how they do it. So they will make it possible that for anything that you haven't performed, all the unperformed obligations, you have to pay back the damages. Right? You don't have to remember the formula and all, but that's what basically it is. Okay. So one thing is, as I told you, they can ratify it. Okay. They can, once they become a company, they can take the responsibility to them. Saying that, yeah, now we take responsibilities for the land that is purchased, and now we are going to build a factory or whatever in that land. Okay. Another thing that they can do is, let's say the promoters had some conditions in the contract, but now the company is like, yeah, we still want the land, but we are not happy with all the conditions. Maybe let's say they fixed an amount of that they have to, let's say they're leasing it, because I don't think at the very beginning of a company they will have a lot of money to purchase. Let's say they leased out the land, they must have some conditions, right? They have to return it within this period, the amount that you have to settle, they call it like an advance you have to pay and all. So now, if they want to change that, they can go for a fresh agreement with modified conditions. That's also an option the company has. They can ratify exactly what happened, or they can go for a fresh agreement and they can make it happen. Okay, so that's the two ways how the promoters can avoid liability, because once that's done, promoters are out of the picture. No longer they are responsible. This is only possible now, because now we have a statutory law in Sri Lanka, right? But if it happened back in 800s, 900s, no. Because no guarantee, no warranty, no protection, right? Now also, nothing has changed with the way we enter into pre-corporate contracts, but now we have a law that protects you. It's a shield, right? For the promoters as well as the investors, right? So this is just explaining 23 subsection 2 within a reasonable period of time, and the period. So this we already discussed, so that's fine. And yeah, that will become valid and enforceable. Okay? Is that clear? Yeah. Any questions? As I told you, they can enter into a fresh agreement by substituting the terms and conditions. Okay. Now, what will happen if they fail to do that? So now, same situation, promoters, they have bought the land with them from the money that they got from the investors. Now the company is incorporated, but this new people, bunch of people who are in the company, they don't want to go ahead with the land. Maybe they change their mind. They want to have their factory somewhere else. Yeah. So what they can do. On behalf of the promoters, you mean? The question is, so good question, right? So let's say you are the investor. I'm a practical person. It's great idea to build a buy land, etc., etc. So you will go and buy a land for me without me getting involved. What if I just run away? So now I'm not in the picture, right? So let's say we are having an informal conversation, right? So you are an investor and I'm coming and I'm telling you I have an idea, I have to start this milk powder company, whatever. And we are saying, okay, that sounds a good idea. But I only have the idea. So you want to now go and buy a land. And you want to enter into a contract before the person is paid, right? Okay. Now you have paid land person and now you have to take land documents. So now if I just go straight, just ran away, what will happen? Yeah, of course. One thing is we pay or whatever, but what will happen to you? So it's a loss, right? You need that land. Now you have this barren land and nothing is happening. So there is no trust or assurance that your investment is protected. So that's why we have this protection. That's why we want this law to be there to ensure that investors' interests are protected. At the same time, promoters are not put into a lot of pressure to take care of the liability on their own. Yeah, because investors, if they enter into a direct contract, then the promoters will just escape, right? Because they are not in the legal picture. All right. So if they don't want to ratify it after incorporation, what they can do? They can go to the court and the court can give you a different kinds of order. Right? Let's look at the orders and then we will discuss why each of them are required. One thing is the code has any questions? Anyone? Yeah. You have follow-up questions?
Consider that the promoter also into the agreement.
You can add it.
Then there's a protection again.
What kind of protection?
So that's it to be safe.
So now you are saying people who are buying the property are investors promoter. Right? The investors putting the money. So now without anything, I am actually getting a land of my name. Get it? I am getting a land. So it's like you are buying me something. So you are saying as investor and I am a promoter, right? Both of our names are in the deed. So then what you can say, who are buying this? X and Y. But X is the investor. He is actually giving the money. But in the agreement, it doesn't matter. We say X and Y, owners X and Y. Then I can go to the court and ask for the land, saying that I also bought this.
No, in between X and Y, there's a clear loss. Promoters and investors.
That's good. That's the question, right? As individuals, they can enter into any kinds of agreements, but it's not going to be valid because we are talking about the company. Yes. No, in the sense that so you and I can, for example, let's take a piece of paper. We can agree to do this. It's an individual agreement, right? So it won't be valid when you talk about a company because company becomes a completely different legal person later. Right? So imagine a situation where at the beginning you are like four friends who have this idea, who pitched the idea, you met the investors, all four of you. But later on at one point, two of them left. But they don't have any responsibility. And the very basic thing is a big investor is not going to sign a check with you. Because it's too risky for me because you don't have any guarantee, warranty, patent property, anything on your name. On which basis you will face the trust? That's nothing, but you are not actually bringing anything to the table. Only when the company starts to work out and it becomes gaining profit, then you can earn your position. You become a share. You have more shares, then you can buy shares, and you will build a status for you. But at the very beginning, it's more or less they are the how many people, they are the powerful ones. Right? So in order to protect yourself from facing any liability and to protect the investors, that's why we have this protection. So if, like you said, if we are going for a mutual agreement between those two, there is no protection that at any point a company will come or not.
Now, can we believe the money? They pay the money.
That's what the guarantee is coming from the implied warranty that a company will come. If there is no hope of company, if there is nothing, it's like two people buying land. That's not going to happen. No one's going to do that. Right? The investor needs something to hold on to. So that's his key. Like he needs something to hold on. Otherwise, it's not even like a company related contract. It's two people buying a land. Makes sense, right? Okay. Do you have any doubts? It's good if you ask doubts because then we can get it back. Yeah? Is it clear why we have this whole concept of pre-incorporation contracts and why we need these protections? So failure, one thing is the court can direct the company to return the property. Okay, one thing they will order, you have to return the property. Second thing is, it will say, we are validating this contract, so you have to go through with it. You have to go through with having this property as your asset. Or they can give you any kinds of grants that you are requesting. For example, you can ask for damages. You can ask for compensation. So my question now for you is, why do we need to get the court involved? Why do we have to take the whole pain of going to the courts? Why? So So for example, if you and I sign a contract, a sales agreement, and if I don't want the land, then I can return it to you. I can just go over and say I'm revoking the contract, and we can finish it off between two individuals, right? Do anything for the government or like state or court? No, because it's between two individuals. We are adults, we made an agreement, then we realize it's not going to work. We are terminating it. That's what happens, for example, in workplace, right? Employer gives you a contract. At one point, you are thinking, okay, I'm not going to work in this company, I'm going to terminate it. What you do, you give a notice, and at the end, you terminate your contract. Yeah. Do you get for any court order? Terminate that? No, because that's between two individuals. But here it says that you have to get a court order. What? It's between two people a contract, no? Then why? At the end, it's a contract between the investor and whoever sold the property. So that is. Okay, let's imagine a situation if the construction has started. Okay. Yeah, so then that's a different case now. The whoever I say looked at construction project, he will file a case to me. Now he doesn't want this building bill, but I already have got all the resources there. You know what I want to hand, whatever something, etc. So that's a completely different case. Right? I'm asking now we only have the land when the company is incorporated, but they don't want to take that and they don't want to ratify it. They don't want to accept it as a company's property. Basically, why can't they just terminate it between them? Yeah. Yeah, so that's why I told you, if it's a breach of contract, and I'm asking why, so for breach of contract, you go to court. So for example, if there is a sales agreement between us, I am a shop owner and you are a supplier, if there is a disagreement and there's a breach in condition, you didn't supply me with the quantity that I expected, that is a case where court will determine whether there is a breach and then they will order compensation. That's a completely different one because you are going to get compensation for whatever happened. Here, I'm saying that you have to get an order as to what you have to do next. So their relationship comes to an end. But here it's about proceeding. But we have to get the order from court. Why? Yeah. Promoters will get affected, but even in individual contracts, there is an additional protection that we don't know. Yeah, the second part is actually correct. It is about the second part is law, exactly. It's the law because implied warranty is a law of the country. So that means if you breach a law, you have to go to courts. Does it make sense? Implied warranty is not written in that contract that they signed between two parties. It's actually law of the country. Company Act is a law of this country, right? So if you breach a law, you have to go to court. So let's take 3 examples. This is one. I want you to place it between 2 different examples that I am giving you. One is employment agreement. You have employer, employee, they sign and they terminate it between themselves. Right? Now let's take a marriage contract. Marriage contract, do you all agree? Yeah, two parties come together and they come to the legal minds to go together with this. Yes? Anyone has an issue with that? No. So we have the 2 parties. Why do we need to go to courts? and get divorced. Why can't we like this is not working out? I am canceling the contract and terminating this. Why can't we do it as an employer-employee? What's the difference between a husband and wife and an employer-employee? Both of them came to an agreement. They both signed it. Here you can give 3 months notice only. Imagine if a wife or husband can give a 3 months notice to leave the relationship. Why can't we do that? Oh, that will be interesting. 3 months notice, bye-bye, I'm going. Done with the relationship. Why? Exactly, because you got the government involved. Though you signed a contract between you two, it is the law of the country that if you want to get divorced, you have to file an application in the court. Right? So when you get the state, like the law involved, you have to go to the court to get an order. Right? Is it clear? The difference between the marriage contract, employment contract, these three corporation contracts. Yeah? Right, good. All right. Okay, so before answering this, let's look at one of your past. Any questions? Any questions? Issues with marriage contract? Any questions on marriage contract? Yeah? No? All good. Anyone have a question? Out of the first question? Sorry, yesterday, so I had a lecture from 3:30 to 6:30, right? So one of the students said two of them said they want to go for Pyongyang. And one said they want to go wedding. And one said he wants to go because he has a page. One said so. They said like I'm staying this, I will go after this. So there are people, right, who are interested in having a personal life. Anyway, no questions? All clear? Do you all know what dating is, right? Don't expect I much guys don't expect the way to what people know you know what dating is. Anyway, right. Question. This is from your past paper. Let me know if you can answer the first few questions. Yeah? You can answer? This one. Can you differentiate how law has changed the common law position to the Companies Act? Finish reading the question. The second one is very straightforward, right? So what are the implied warranties? One. What are the two implied warranties? Two things, and I said, and so must. Two implied warranties from the Act. Yeah. One is that company will be incorporated within a reasonable period of time of the expecting fact. Second, it should ratify it. Right? Two things. Incorporation, ratify. Okay? So that's very straightforward, right? The second one. 1 plus 1. I told you, right, that the law changed after the Companies Act. So what was the previous position? That at the time of contract, since company is not in existence, it will not take responsibility for any of the contract entered on its behalf. Right? So who takes the responsibility? The promoters. But later you can say with the introduction of Companies Act, it gives a layer of protection to the implied warranty where the responsibility can be transferred to the company after incorporation and ratification. You can cite one of the cases here. Yeah. Any questions on that? Yeah. So do you remember the case? Question? If you could just remember this one Fenelon factor, that's sufficient. The thing is, the slides that Sir has, most of the time they only have the case names. Sometimes he has included the facts and judgment, but sometimes it's only the cases, right? But I have included the explanation that you have to understand, take it to your brain, take note of it, because not all of this will be uploaded to the LMS. Because the slides will be uploaded. This I'm doing extra to what is given to me. Okay, so try to understand the case and take like very simple note, right? If it is about the wine case, just remember they purchase wine, they make the payment, later they got into liquidation. Just the keywords, that's enough. Okay. All of these cases, Sir has only given the names. I checked his slides, so better if you could. So the purpose usually is when if you are a full-time student, usually how law is done is they introduce you the case, they will just brief you, but later you have to go and research, study it on your own. But of course, you don't have the time to do that, but still take note of some of the facts presented here so you have an idea. Because before the exam, the day before exam, if you open it, all of them will look the same. Trust me, that's how law is. If you look at the cases, all of them will look the same to you. So try to make sure that you have some notes regarding that. So that's the question. So I'm sure in exam, if you get these 2 questions, you will all get 10 out of 10. Yeah? No? Yes. This slide. Because this is not prepared by myself, so I have to ask permission from Sir. Let's see, but I can serve the same. They are doing some homework.
Promoters enter into the agreement. It's a promoter will be, and in 6 months, it's a promoter's passed away.
Good. Right. So let's imagine that's a situation where promoters pass away, right? The property is already sold, right? So the company. Yeah. So yeah, assuming they only had that one promoter, is it? One promoter and he's no longer there. The top exactly the reason still the company can be incorporated, can be ratified, and the company will take responsibility. The problem is in the previous law, if promoter is gone, investor is with empty hands. And you see, why we need, like you said, person escaping, person dying. No matter what happens to these promoters, still there is this assurance that the company will take care of. But in the common law, that was not the case. It's similar, same situation, escaping, dying, going missing, all of them. All right. Yeah, we talked about implied warranties and the. Okay. So now we are going to look into the contracts that the company will enter once it becomes incorporated. Right? Until this point, we talked about contract entered before it is incorporated. Okay. So now the company is incorporated. So now it has a legal personality. It is a person. The company has entered into a contract in its own name. Right? But you all know, right? The company has a legal personality. Yes? Yeah. So what will happen is, just like a natural person, just like me, you, a company will have all the obligations required to enter into a contract, and a company can come and sign a document. Yeah? Yes? Can company walk in and sign the document? No. Then we need to know who can sign that document on behalf of the company. So it has to be written, signed, and authority executed. If it has two directors, both directors, if it's only one director, that's the rare scenarios. Most common one is in the articles of association, they usually assign a person. Right? They usually assign a person to take care of these matters. Maybe he could be the company secretary, or maybe the legal officer, someone to sign all kinds of contracts. Some like huge companies, they even have a contract manager, one position for contract manager. So they will have multiple contracts with so many different people, right? So in order to maintain that, to renew it regularly, to make sure that the conditions are met, and when law changes that they are in compliance, they are compliance officers, they will take good care of that. So attorneys can also be appointed, as I told you, compliance officers or contract managers. They can be an attorney, right? So we looked into companies that are entered into before incorporation, and these are contracts that the company enters once it becomes incorporated. Now it's a person. It has its own name, it has its own legal personality, and now it will proceed to have its own property in its name. Yeah? Is that clear? All clear, everyone? I'm sorry. We have one more. So, unless it is specifically stated out loud that it is required to be in writing. In most of the occasions, that's how companies function. For the safety purpose, they always go for writing, right? So you can assume that the person acting under the company can have express or implied authority. I explained this earlier, right? One thing is expressed. An example is in articles of association, you clearly expressly state in writing saying that this person is responsible for signing any document relating to the company. Or if it's implied, if it's only a director and they haven't specified anything clearly in the articles of association, then we can safely assume that the director has to sign it, that they have implied authority. Right? Two things. One is express when you write it down or say it out loud, or the other one is implied. Right? And another one is there are occasions where if they have clearly stated that they don't need in writing, that can also be done. Why? Because in Sri Lanka, we accept oral contracts as well. Oral contracts are well. Section 19, subsection 2 says, regardless of where it entered into, whether in Sri Lanka or outside of Sri Lanka, or whether the contract is governed by Sri Lanka or not, it comes under the Companies Act. It will be governed by the Companies Act. It becomes studied within our legal system. Right? Is that clear? All right. So that's all for company. Do you want me to start the next lesson, or you want to be? Okay. What's the next one? One already? One. Okay. Then we'll see you. 1 hour is enough? Not enough? Your birthday celebration is over, right? You don't have any, like, any other stuff? This is. Okay. You took like early break early. That's enough. Okay. Go enjoy your lunch and for companies. Yeah, so employees that they will be governed by the labor law, like in employment law, because the relationship that they have with the company is employment. Now I'm asking about people who have a relationship with the company. Directors, yes. Shareholders, yes. The other one, secretaries, yes. Auditors, right? So those are the most important ones that have a direct relationship with the company. Employees are there, but they have a relationship based on employment. And then we governed by labor. So now we are going to into the appointment of secretaries in a company. What are the qualifications? Whether they should be the approval, how it changes, whether that's an evolving concept or whether that's a fixed position, different change, and yeah. Right? First one is appointment. So it says every company should have a secretary. As I told you, should have emphasizes that it is a mandatory rule. You need to have that, right? And it specifies that one that has a turnover of 1 million rupees or more or their stated capital is 500,000 rupees or more should have a qualified secretary. What's the difference? Just the secretary and qualified. The second scenario is where they are expected to at least have some background or experience in accounting. They have to have not just a mere secretarial work, because if you take you are all in different like clubs and all we do, right? Different clubs, I don't know, art club, dance, whatever. So they also have secretary, president, secretary. So what's the role of the secretary in like a general sense? Taking minutes, more or less, that's what they do. And at the end of the year, they make a report, right? So mostly it was clerical, doing writing works and more or less kind of recording whatever that's happening. But in company, they are specifying based on the value of the company, is capable of understanding the accounting aspect of company matters, right? Of course, you cannot appoint someone as a secretary without their consent. That person first need to consent that I am happy to be a secretary. You can't just pick someone and make them a secretary. Okay? So they basically hold an administrative position. So as we talk about it, it's more or less like an admin work, right? They take care of the meetings are arranged properly, right? If there's an AGM, they make sure that the poll is through. They have to get a poll. They make sure that the notices are sent to every people, that everyone's attending, right? Basically, admin work, sending notices, taking minutes, all of that stuff. Right? They are not involved in the day-to-day management because technically they are not like managers. What they do is they help the smooth functioning of the company. So in many places, you must have noticed that company secretaries are lawyers because they do have a title for company secretary. Once you complete your commercial law exams and the attorney's exam, all the people who pass out as attorney laws are company secretaries. They are capable of having the title as company secretary. They don't necessarily have to go to that company every day. They don't have a day-to-day task to be completed at the company. They have to be there when prepared and they just have to make sure that their tasks are completed on time. So the most important part, as I told you earlier, is about entering into a contract and making sure all the necessary legal implications are properly addressed during the process. So that's why it's always a good practice to have a lawyer as a company secretary, because they can handle the legal side of it. They can, of course, they know how to handle a contract. Right? So secretarial means technically not like just taking minutes in the sense of a company, but also taking care of the administrative work. One main task would be to handling management. The contract management comes in there. So here, the earlier we talked about fiduciary duties. You recall? Fiduciary means trust that we keep, what promoters have towards investors. Fiduciary trust duty. Similarly, here also they have a duty towards the company similar to that of a director, because they are entrusting them with certain tasks and they are expected to deliver it. Okay. Now, let's look at the qualification. You can see, of course, he has to be a citizen of Sri Lanka and ordinarily resident here. That's clear. Most occasions, it's an attorney at law, but people who are members of the Institute of Chartered Accountants can also be secretaries and administration in Sri Lanka. And SEMA, etc., can also be. Right? But the thing is, when you propose someone as a secretary, and you all know that your documents with the names and all with articles of association goes to the registrar as a company for approval, right? We did learn about their involvement, why we send all the documents, why we send the reporting goes to the registrar of companies. And here they need to be satisfied that this particular person that you are proposing is competent enough to fulfill this particular role as a secretary. So, any questions on this? Turning a flow, and you all will be joining number 2, chartered accountants. Yeah. After you graduate from here, is there a different procedure to join this? You have to do anything else? CA exams? If after you graduate, you have to do the CA exams, or if you do the SEMA exams, then you can try to do the. Okay, so it's not like membership, but you have to pass exams and then visit. More or less, even joining the legal professions, like you have to pass the exam. Okay. So once you become this, you can also be a secretary if you want to. Right? Okay. So this is the interesting part, how the law relating to the authority of a secretary changed over time. Okay. So you must have seen in shareholders, their powers and remedies, even in directors, it was not the same from the start. It kept evolving, it kept changing, right? The level of standard expected from them. So here, we are going to focus on the case of Barn Forest and Company versus South London Sandpace. Okay? So this case is where, for the very first time in 1887, as you can see, it's a record case, where the court interpreted or gave their opinion as to the role of a secretary, who a secretary is, what a secretary can do and what a secretary cannot do. Right? Okay. So take a minute to read this case. One of you is going to tell me, because you all are sleepy and that's me. Sleepy, so it's not gonna work. Please read and tell me what's in this case. I've highlighted the important key terms also for you. You want to give it a try? This is only describing the issue, right? We still haven't looked into the decision part. But first, let's understand what this case is about. What's the issue that they were trying to resolve? Yeah, anyone? Finish reading? I'll just share the screen so that I don't phone you. Yeah? This case, first thing is it's a contract about what? Let's go one by one, small questions. The contract about what? Land construction. Good. Do you all know what plans is? Well, at a train, but I can't think of it. Lanka, we don't have that, but many of European countries do have. It's more convenient. Right. So basically, they want to do this and they have that money, but the issue is that they has mistakenly have put a higher amount than what it was. That's the problem. So now there is a discrepancy means there's a conflict difference, like it's not the same, it's not matching. The value is not equal to what is entered into the document by the secretary. So now it's a problem. Now let's see what the court held about this problem, whether the secretary is responsible for what he or she did, or whether the company should take responsibility, personal liability of the company. Answer. So the decision is just in one line. The court held that the company secretary had not had the authority to bind the company. That means his personal actions cannot bind the company. Right? Why? Because the explanation is, again, as I told you, Lord Lordship, the judge, the secretary is a mere servant. Right? His position is that he is to do whatever he is told, and no person can assume that he has any authority to represent anything at all. Nor can anyone assume that statements made by him are necessarily to be accepted as trustworthy without further inquiry. So whoever the people who completely relied on the secretary's report are in trouble. Why? Because secretary position is not something, it's not like an accountant's report. It's not like an auditor's report that they can rely on. He is merely a clerical staff. He is a secretary. So making any decisions based on that, making any transaction based on that will not make that person liable, either the company, but whoever trusted that and proceeded with it. That's what it says, that no can anyone assume that statements made by him are necessarily to be accepted without further inquiry. So you can see a secretary at the start, like when companies was merely kept in a clerical position. That's why they didn't put that pressure of knowing to know basic like accounting stuff. But now you can see we looked into amounts, right? Earlier, the more than how many millions of credit capital? Why we are setting that when the value of the company goes up, it has to be with more accounting stuff. So we need to have a secretary to understand that. So that's why at the very beginning, a secretary was treated as a merely a clerical person who just arranges meeting and take minutes. You all know 10 minutes, right? When whatever that happens, they write it down. This person said this person agreed on this. So that's how it was treated back then. As you can see, it was in 1887. But later in 1971, this particular case, Panorama Developments versus Village Furnishing Fabrics Limited, changed the way how courts look at the role of a secretary. So this case changed it. See how? Here it talks about the implied authority the secretary has to enter into the contract. Right? So please think of the timeline here. Okay, back in 1887, it was merely treated as a clerical staff, right? Who just take records, who make sure the meetings are done properly. That's what the secretary was. Then later, slowly, they understood the importance of having a company secretary. And then later with the development, the need and task given to a secretary increased over time. So later they were understood or assumed to have the implied authority to do any kinds of practices that is customary for that particular company. So in this particular scenario, if hiring car for that particular business is a common practice, then the court held the secretary have implied authority to do that. Okay, so you can see the way court looked at the previous case is completely different. So the important element of law is if this case happened in 1887, the ruling would have been very different. Like they would have ruled it in a different way. If the previous case came here and if he has actually made a mistake, they would have said no, that is binding on that person. Right? You can see how law develops, and it is a judgment given to that particular case for that circumstances, considering whatever the law is at that point of time. So it just keeps changing and evolving. An interesting part about law, at the same time, it's difficult to keep track of the changes. Right? So don't get too confused. Just think that the role is ever changing. That's similar with director, because you looked at director's duty, right? At the very beginning, they said they have no responsibility towards the shareholders. Then they said yes, they have to inform them. Full disclosure is important. Later they said we have higher expectation of reasonable exercise of skill and care. Similarly, a secretary's role has also evolved over time. Okay, so we looked into two cases, and you can see how, like 100 years gap, it changed. So this is how first slide will look like. So I gave you the explanations, but this is the slide that sir has prepared. Basic idea, sir will just explain it to you, and then you have to write it down. So basically, it is that earlier a secretary was treated as a mere servant, a clerical staff who just do admin work, but now he is treated as an officer of the company who takes part in considerable amount of work and who does have authority to do certain things on behalf of the company. See, he's the primary officer and he is an agent who can exercise company's administrative work on behalf of the company. Right. But it is advisable for the secretary to consult the members in the higher positions whenever he makes decisions that are not customary for that particular company. For example, hiring cars every year, if that's something that they do. And this year also, if that's the same person who is renting out these cars, it's fine. But if they are going to change it, if there is a rise in the price, for example, after COVID, after this economic crisis, all the prices went up. So maybe last year they had a track for 1 lakh, but this time they are asking, we can't afford to give you for 1 lakh, they want to go for 2 lakhs. So now that's a decision that a secretary cannot do. Why? Because it's not customary to go for that particular practice. So now it's a change. So then he has to consult, get some opinions from the higher officials before making a contract. But generally, it is common for us to assume there is implied authority for a secretary to carry out any kinds of activities, tasks that's normal and customary. Okay? Even if there are slightest small changes happening, then they have to consult. It is always advisable for them to consult before making any steps, because if he completely relies on his judgment and carries forward any of the tasks, and if that ends up in affecting the company's revenue, maybe a reputation, if it's an advertisement or something, then that person will be held personally liable. Right? So that's the important part. The problem is like why he needs to ask the other people, because if that goes wrong, and then if they file a case against the secretary, he has to be facing the case alone and he has to be fined personally liable. Right. What are the powers he has? Of course, he has the power to make contracts, enter into contracts, on behalf of the company. And look at what he cannot do. So in your exams, you have part A and part B type of questions. Maybe in a scenario, they will give you a secretary did X, Y, Z. And then they could ask you if this is permissible, if this is something you can do. Right? So that's how your knowledge on company law is tested, how you really understand it. Because, for example, if the company secretary is about to borrow some money on behalf of the company where you are working, then you have to be well aware of the fact that that is not something that he is authorized to do. He cannot borrow money on behalf of the company. What's the next one? Okay, first tell me, what is trading contracts? Trading. Yeah. It's fine, even if it's wrong. Yeah, but almost all contracts are commercial and business related, right? There's a difference when it comes to trading. I think even in accounting records, we had a distinction between trading accounts and this one, right? You know the difference? This trade. Revenue, in general sense, yeah, trade law, but and okay, let's start with the yeah. There's something else that I'm missing. Anyone? Trade? Okay. That's how it's defined in your accounting practice. Yeah, I remember. Yeah, we also had trading accounts. Okay, but here trading contract is slightly different. But before that, let's finish the other two. What about third one? What does writing a name of the registrar of members mean? Right? Removing it, right? Secretary cannot just remove a name from the register. Right. The next one, summon a general meeting on his own authority. That's clear, right? He cannot call his own meeting. Because that's not his job to do. Who has the power to do that? Who can call a meeting? Exactly, right? We did learn about meetings, annual general meeting, extraordinary meetings, yes? Coming to the brain, yes? Yeah? Okay, so board of directors has the power to call the meeting of the secretary. So the role of secretary is merely to pass the message once it comes down to him or her. Okay? They cannot on their own do it. Alright. So striking of their name, of course, that's not something that they can do. Okay, tell me occasion where a name will be stricken off, like where it will be taken out, removed. The register. Yeah. Yeah, good. That's a very easy answer, but yeah, that's true. If someone says that we have to remove that person from the register, very true. Very practical one. Okay, more into the company's regular affairs.
Yes.
Resignation. Do we say people resign from company membership? That resignation is more of an employment term, right? What they usually do? Withdraw, yeah. Shareholders, they can sell out all their shares and they can leave, right? They do the what else they can do? Yeah, more or less, that's what how they basically leave, right? So that's the occasions where a name can be taken out, and that has to be followed by due process, right? Reasoning stated why this person is no longer belonging, that he is why he does not belong in the register anymore, right? Okay, so trading contracts, because it's important for you to understand. At the beginning, we said that they have the power to enter into contracts, like make contracts, right? But trading contracts are future contracts. That means it's not something that you enter. Now it's like in the negotiations in which later on will become binding. So those decisions that cannot be made by the secretary. Why? The terms and conditions are settled, aren't fixed, right? It's ever changing, it could change in the last minute. So they cannot enter into such. So as you can see, his role, his or her role is more or less about certainties. If it's something that's regularly happening, there's no big changes, he can just go ahead and do it. For example, renewing a license. That's something every year he has to do it, he can go and do it. Every year they sign a contract with, for example, if they don't have a parking spot, they need to get contract for a parking spot that's there. That happens for the 10 years now. 11th year, simple. The secretary can go ahead and sign that. But any new contract, any future contracts, he cannot do so. Because the terms of that, the parties of that, in conditions, and everything has to be discussed and finalized by the higher officials, not the secretary. Right? Okay. So anything that requires the authentication of the secretary, he can sign and proceed with it. For example, documents that need to be sent to the registrar of companies. Since they are, if it's a lawyer or if someone who is familiar with this, they know once accounting, whatever, etc., everything is prepared, they can make sure that it is authenticated and they can just submit it to the registrar of companies, right? And if there is any other document that needs to be signed, then they can also do that, any kinds of certificates. So things that there has to be a very clear clarity as to that this particular person is authorized to do that. That's the very important thing. Because unlike a director or a shareholder, secretary is a what? Paid position, right? So on one hand, they share a relationship with the company as an employee, because earlier you said employees, but when it comes to the capacity of secretary, they get some authority, unlike other employees, right? So their job title changes their nature, but still they are an employee. So they have a labor employment kind of relationship, but they also have a company related relationship with this entity, right? So it's a mix of both. Proceed to auditors, right? So secretary, the main things that you have to remember is earlier it was merely treated as a clerical staff and admin staff, but later they have realized that they are part of the company and they are doing more than just clerical work. So we can assume implied authority on secretaries. So if it's a normal and customary task act that's happening within the company, then they can proceed and do that. They can enter into contracts, but they cannot bind that contract for future contracts. What else they cannot do? Yes, they cannot take money, borrow money on behalf of the company. They cannot remove name from the registrar. Last one. Yeah, they cannot do any kind of thing. They are all because they are not given with that authority. All right. Now I explain. Let me actually. It's an auditor. I'm sure you all know. Yes. You all have to tell me who an auditor is. Yeah. What's happening? See, if someone laughs for no reason, they are called something, right? So be mindful. Don't do that in public. Okay. All right. There is something, but you can just say we don't want to share that with you. All right. So basically, an auditor is a person who makes an independent statement regarding the company affairs. Okay. Right. I'm sure you all know the technical stuff here. So basically, you can remember from our accounting lessons, they have to make sure that the statement is true and fair. It gives a true and fair view of the affairs. So, first auditor, when they appoint the first auditor, they have to make sure that all the members are aware of this. So, annual general meeting, they have to propose this, and everyone has to accept. Okay, we are fine with proceeding with this particular auditor. If the board doesn't appoint someone, then later in any other meeting they can appoint an auditor. So as you can see, a subsequent auditor can be appointed, but there are some issues where he will not be reappointed if that they felt that he is not competent. Even if that person is considered as not qualified for the job. Maybe he might have the accounting background, but maybe not to handle that scale of a company. So that's up for the company to choose, because at the end of the day, they want the best for them. Okay, right. Or if they just decide that they don't like that person, or maybe he has a bad reputation in the market, and if they think that he is not someone worthy of that position, then they can go for a solution, they can decide on it, and they can proceed to replace that person. Because of course, because auditor is a job that requires a lot of honesty and reputation. So if he has bad name, maybe like got caught with any frauds or something, then they can move that person. And there can be occasions where the auditor himself doesn't want to continue in that same position, right? He wants to retire, he wants to go for another company. He can also inform that through a notice, and they will go for the replacement, right? It's like very technical stuff, like how things happen in the company. So that's not very difficult. Okay, partnership as auditors. Maybe this is something new. You heard of this before? I don't think so. Where more than one person is given this position. So all of them are responsible for whatever document that's prepared. So imagine it's like a very huge, like an enterprise, not like a small company, but an enterprise. So they have more than one member. So that whole entire partnership, that the entity, that the group is given the responsibility as auditor. Okay, nothing like difficult to understand. Just that they are the partners of that firm. All has to be qualified. Okay, and this is again straightforward. Either the person has to be a member of the Institute of Chartered Accountants or a registered auditor. What's the difference between these two? Institute is the private one, right? Registered auditor? Any idea? Yeah? So because I'm not too sure, because I tried to find this because this is new for me, but I couldn't find. The first one is clear, right? Because it needs to be a member. And the second one, if it's a registered company secretary or registered notary or whatever, that I'm assuming it's the same, because if you take an attorney at law, as I told you again, they are a company secretary also. But what they have to do is they have to register them as a company secretary. So once they become company secretary, even if they are not a company secretary for a company, the title will stay with them. You get it? Like, if, for example, if for me, after taking oath, they will give me a number. So I can go to the company secretaries and I can get my name registered. Once that's done, I can just add company secretary after my name. But I don't necessarily have to be a secretary in a company, because it's more of a title. Similarly, once you register yourself as an auditor, I think you don't necessarily have to join the institute. Even if not, you will be considered as a registered auditor. Even survey officers, they are called registered survey officers, right? Of course, the institutes are there to make sure that they have codes and practice, but you remember, they can only make codes and practice relating to ethics. They cannot make law. Okay? You all understand the difference between these private entities and what the state can do, right? The state actually gives you the power to practice whatever your expertise, law, auditing, accountancy, whatever, right? But these institutes are there to govern, to have a proper corporate governance, right? Corporate culture. So that's what their role is. They don't make any laws. All right. Disqualification. First one is obvious. If he is not a chartered accountant or registered auditor. If he is a director or an employee of that company, then he cannot be a. Why a person who is an employee cannot be an auditor? Independent, right? The role itself is giving an independent opinion, independent report, right? So a person is an internal one, that independent cannot be protected. If he's a partner, if he's employed, whatever, right? If he's an liquidator, administrator, whatever that is, cannot be. And of course, body corporate, that means a firm or another company cannot be an auditor, right? It has to be a member. That's why we have introduced partnership auditors. Partnership auditors mean those individuals have to be named. That's the difference. You can't just name a particular corporation. Okay? And also, if he is not qualified to be appointed or accepted, any other relationship he has, maybe a relationship as like he's a legal advisor and also an auditor. He can't do that. Because I know people who are qualified chartered accountants and also lawyers, but they can't wear both the caps. They have to choose and they have to do only one. Because if they are handling legal matters, that means they are to a certain extent exposed to the internal affairs. So then you cannot really protect that independent nature by telling them that they will give a genuine, true, fair view as a third party, as a third person. Right. So, fees and expenses, something you must be interested. You want to become an auditor and make some money. Yeah? Are any of you already working in like an auditing firm here? Yeah? Okay. Do they pay you well? No? They don't? Maybe once you become a senior person, they will probably pay you. Okay. So it's something that should be fixed, right? And if it's decided by directors have to fix it, and it's a registrar, they have to fix it. But do you know comparatively that they have to pay a reasonably high amount for auditor? Do you know why? Why they do that? I'm going to give you some other professions where there is like a requirement that they should be paid higher than like a market value, like an average. Judges and then customs officers. Think of these three people and tell me why do you think that's a need that we emphasize that they should be paid higher than like a normal value. There's some similarity between these. There are some specific. Yeah. Absolutely, like they cannot let any of their personal interest affecting them. So they should not basically take bribes. So if they are well paid, if they are well fed, then that means that's assuming that they will not go for bribes and all. So that's like the assumption. That's why they make sure customs officers, because they are the ones who have to find faults. The job is that, right? So if someone buys a customs officer, that's going to affect the entire industry. Similarly, judges, the auditors also the same way. Right? That's why there is a common understanding that they should be paid more than their market value, because their personal interest should not affect their work. They should not take bribes. Right. Fees and expenses. So they have to prepare a report that we discuss, and it should be consistent with the annual accounts. That's the. Okay, so this is like the main focus of the law subject, right? Technical things you know. Just remember, of course, you all know who the auditor is. Remember the qualifications, how they are appointed, and now this. These are like the main things you have to remember. Right? Duties of an auditor. So he has to prepare the reports that I think more or less a repetition from the previous slide. So I think you all know that. So what should be included in a auditor's report? Can you tell me? Opinion, right? That's a good one. What's this opinion? That the coffee served in the company is good? Is it an opinion that the auditor can write? Coffee served in the company is good? What kind of opinion? The evidence based, right? So, opinions relating to what? That's absolutely correct. The evidence based, that means it has to be supported by evidence. You can't just randomly take it. Right? Okay. What kind of opinion? Opinions about what? Financial statement. Transactions, okay. And accounting related practices. If there are some malpractices that identified, we have to make an opinion about that. What else? Can we make any opinions, comments about the management? Anyone thinks he can? That's not his job, right? It's not his job to do. Okay. So mostly it's going to be about like the accounting stuff, like how it's done, and the other part is whether they are running the company up to the accounting standards set by the state and also the private organizations, right? And the institute of, like, they have to make sure it's up to the standard. And that's like the main work. So if there are any malpractices, they need to point it out. Right? Okay. So let's have a look. First one is the basis for opinion. So that's what one of your friends mentioned as it should be supported by evidence. There needs to be basis for his or her opinion. The second one, the scope and limitation of the audit. That's important because every single thing that he's doing there, he has to first make sure that he is protecting himself. Right? Because at the end of the day, he's giving a report which outsiders are going to rely on. Right? So if something goes with that report, then who is in trouble? The auditor. His name's going to get affected. So what he has to do is he has to very clearly at the outset say that there were these limitations were there for me. I couldn't access this particular account. This information was not given to me. I only restricted myself to looking at these documents. He has to make sure that he is protected first. Right? That's why it's always important to define the scope of your. So that's similar to research, right? Even when you do research papers and all, what they do is they define their scope. So you can't go and like do research on everything, right? So you must have seen even in your like groups, they must have like sent you Google links saying that they are collecting data for their thesis or something else. You must have seen that they must have chosen a particular group of people or people with particular practice. So if it's like marketing people, they will choose people from particular age or women, men. They need to have their limitation and scope fixed so they can within that boundary make sure that they efficiently provide a report. They can't just randomly do it. Okay, right. Now see whether the auditor has obtained all the information and explanations that were required. So for example, if there is an occasion where the auditor thinks he needs to do further inquiry, and if the company fails to facilitate him to have that inquiry, then he needs to mention that I tried, but I was not allowed to, or I couldn't meet the directors, something like that. But he has to make sure that is mentioned. Right. Right. That's true. Proper accounting records are kept. Financial statements are done fair as long as they give a true and fair view of the matters relating to the company. Right. And also the requirements as stated in section 151 and 153, where we learned under accounting records. All of those standards are met, or whether they have failed to adhere to that standards. Right? So probably they might ask you a question like this as well. What should be included in auditor's report? Right? So you should be able to at least write 4 or 5 of these. Right? So first one, basis for opinion. But just don't write basis for opinion. Add just one more sentence saying supported by evidence. So that's the full explanation, right? Every single thing he's saying should be supported by evidence. Similarly, for a scientific report, everything should be supported by evidence. Right. They have to avoid conflict of interest. As I told you, that's one reason why they get paid more. That's another reason that they cannot intermingle their personal relationship into the professional one. Because anyway, like, they are all in the same sector. Auditor, accountant, director, they all must be friends. They all must be maintaining personal relationships. But he has to make sure that he is not letting that affect his professional exercise of job, right? Professional exercise. Basically, when he is doing his job, he has to make sure that it doesn't affect in any point. Okay, so that's why it says have to make sure that its judgment is not impaired, not affected by reasons of any relationship, interest, or anything. Right? Okay. So let's take an example. If the auditor is married to the daughter of the director, okay, do you think that's a personal conflict? Yes. Right? Similarly, of course, friendship is not something they usually consider. Mostly they will first go for family. Because friends, we can say, everyone is my friend, right? So that will affect their capacity to function at all. But mostly what they will go for is family relationships, right? This is not only for auditors, even in legal professions, if there's a personal conflict, if the client is in any way related, if the client is in any way known to that person before that case, the opponent is known to them, they have to withdraw. They have to inform the person, they have to withdraw. Okay? So you cannot let your personal conflict of interest affect your judgment in professions. All right. What kind of rights they have? First and foremost, they need to have access to all the accounting records, right? I'm not sure, but I'm asking out of curiosity, can a company say like this particular record is confidential, that we don't want to share with you? Can they do that? I mean, yeah, of course. I'm sure it's much difficult. But if it's financial stage relating to this finance, that no, right? Maybe if it's like policy related or maybe documents, for example, they shall be, for example. Because that's an occasion that I know that they can, because an auditor cannot force someone to give the personal details of the employees, because that is protected within the company. But if this person takes the Excel sheet of all the people working there and their phone numbers, right? Because he's at the end of the day an external person, so there is no liability that is affecting to him. So of course, I know other details, not financial ones. I don't think anything can be kept away from him as confidential, as long as it's relating to the account record. Yeah. Any thoughts? Okay. Keep anything as confidential. Right. So they sign a non-disclosure agreement. So do they get access to extra details? But financial terms, absolutely. So every single time they have to sign this agreement. Every time. Until that point, time is gone, you will spend your days to maintain the confidential. Yeah, makes sense. Right. So they have the right to get explanations from the staff. He has the right to receive notice of general meeting. Like he can go and attend these meetings, right? He can observe, and he can visit branches. He can see legal and technical advice. He can claim remuneration. I told you, right? He can get paid fees. Yeah, obviously. He can refuse to commence the audit. That's also a right. Can you think of an occasion where an auditor will refuse to commence the audit? You want to work in so let's start. Right to refuse to commence the meeting. Start it. Refuse to start. Yeah. Okay. But I'm asking where you can take. So even after signing that letter, if the company doesn't provide him with all the necessary materials, he can say, I'm not going to start. Right? Anything else? Any other practical examples? They are now you want to start. Usually, the other ones can submit the documents to this, right? Okay, all of you. You're saying before even he starts. Okay. I think that's a really good one, right? So if the directors don't sign off and saying like this is prepared by us, now it's ready for audit, then I don't think he will start this auditing because what's the point? Like, no one's going to take responsibility for it. No point in proceeding. So he has to wait till that's done. Yeah, so that's good advice. And I think you can see like they have a right to work, at the same time they have the right to refuse to work if not all the conditions are met. Right? Okay. And definitely another occasion that I can think of is when he committed to start the job as an auditor, whatever, he didn't realize. But then later he realized one of his cousins or someone's working here. So he learned about this personal interest later. So now he wants to say, like, I have the right to refuse because now I realize that this person is working here. Or maybe he worked there a year before. So then that's up to the director's discretion to decide whether they want to continue with this person or not. But it's the duty of the auditor to inform. That's the important part, right? So even in a lawyer context, that they have to. For example, there are an occasion where similar to a parking situation where they went and mentioned this to the judge. Right? So what the judge did is they called the other party and asked whether you have a problem with this, that it is a distant relative. And if they agree no, they can proceed. Because you can think of this way. If it's a distant relative, and if you have never talked to that person for the last 10 years, you can't simply, bring that as a reason to stop you from working, right? So it has to be judged properly in that matter. But if he personally realizes that, he can say, I'm going to reveal this matter to you, I'm going to reveal this information to you, management, you discuss and come back and tell me you're okay with it. As long as I get your approval, I am happy to proceed. Make sure that my judgment is not affected by any of my personal interests. Okay, he has the right to question the board, yes, and to qualify this report. Yeah, of course. And so I'm sure these are like technical terms that you use. Unqualified, qualified, adverse, disclaimer. Yeah, these are the terms that you use in the report. Okay. And right of indemnity. What's that? Must have learned it in law control if you had that lesson. Do you know what you mean? Probably you have learned about it. What does it say? Yes, right? Of course. It's different remuneration, right? The one thing is he will get a fee, like a fee, and also there can be occasions that it will be given food, transport, for allowance, right? So it's different from compensation to remuneration for the work that they do. Right? Basically for a pay. All right. Cases. Let's look at some broad things. Chairman did. Cases. This basically highlighted why auditing is needed, why we need to have auditors. This is a very interesting case. If you are interested to know a bit more about it, just Google this and see you. Not too sure, but I think there is like a documentary or whatever about this case. Okay, so basically what happened in this case is the chairman and accountant they work together in collusion to do fraudulent activities. Okay? They showed to the world that they were doing all fine and making profits, but they were actually not. Right? So this case highlighted the need why we need independent auditors from the outside to tell us what's actually happening. Because at the end of the day, whatever, like within the company, they are going to believe what the director is saying. Right? So back in the time, they wouldn't have had the capacity to have an auditor and all. They would have just accepted whatever the director is producing. But later, once this report comes out, they can actually see whether that goes in hand with the report that's prepared by the director, if it's right, or if there are some discrepancies. One last question. Sorry, I'm learning a lot from you. So, auditor's funds is that's confidential report. This report once it's given to the should it be maintained confidentially with this report? It becomes public. Once it, okay, so that's available to anyone. Only some members. Right. Registered companies, yeah, makes sense because at the end of the day will become public document, right? Oh, right. So as you can see, that's the idea, but just remember